Good morning, y'all. I'm back again. The host, y'all already know the routine. I am the Supreme Litigant. Before I begin, y'all please hit that subscription button and that like button. I'll give y'all a second to do that. All right, I'm going to jump back into this. Sorry about that, y'all. I had to make another video because the first video that I was recording, it wouldn't let me resume the recording. So I had to end that one and upload it and do another video. So this would be called Traffic Stop is an Arrest Part 2. So I'm just going to read y'all some more stuff from my community section on my Facebook page. Generally, an arrest occurs. Well, I can't get these words out my mouth sometimes, y'all. Generally, an arrest occurs when one's freedom of movement has been curtailed such that a reasonable, ordinary person in a defendant's or suspect's position would believe he is not free to leave. That is basically when you're arrested. Basically. Here's the cases that support it, blah, blah, blah. And then here's corpus juris secundum on arrest, section 2. An arrest has been defined as the taking, seizing, or detaining the person of another either by touching or by an act which indicates an intention to take him into custody and subject the person arrested to the actual control and will of the person making the arrest, or any deprivation of the liberty of one person by another, or any detention of him for however short a time without his consent and against his will, whether it was by actual violence, threat, or otherwise. Now, they do call traffic stops detentions, okay, but they are, as a matter of law, arrest. And I'm convinced that they are, in fact, arrest because your ass is making a bond. You're posting a bond. That traffic ticket is a bond. Obviously, like I've stated earlier in the first video, they do it different. They don't do it all the same everywhere. It's different. So y'all need to, when you get a traffic citation, wherever you are, you need to read it and see what are the qualifications. They may require you to post some type of security or something, and it pledge some type of security or something like that. That is an admiralty bond. If they're requiring you to pledge some type of asset or something like that, that is an admiralty bond. As a matter of fact, I'm gonna read that to y'all ass again in this video because I want y'all to see what these people are doing. This is commerce. This is business. This is admiralty. All of it is. I'm convinced that they are litigating these traffic citations under the jurisdiction of admiralty, and they may be applying some sort of equitable equity principles or something like that. I have to figure it out because I'm not really sure yet. But I'm going to have to figure it out. What I do know is admiralty courts are civil law courts. Civil law is the study of statutes and codes. And when they file these so-called criminal charges against your ass, they're doing it under a statute. That's what they're doing. They filing lawsuits against you, man. That's what they doing, y'all. An arrest occurs when a reasonable person being detained or held by the police would believe that he is not free to leave. An arrest has also been said to occur when one's freedom of movement has been curtailed. Let's see. The existence of an arrest is dependent upon the existence of 4 requisite elements. This is in Ohio. An intent to arrest under real or pretended authority, accompanied by an actual or constructive seizure or detention of the person, and which is so understood by the person arrested. A person is seized when a reasonable person under the circumstances would have believed he was not free to leave. We believe that all 4 elements in Baker were met here to establish an arrest of Nelson and not a mere detention. Let's see. Here's another one. It is not the actual physical taking into custody that will constitute an arrest. An arrest is complete whenever a person's liberty of movement is restricted or restrained. A person is seized if a reasonable person would have believed he was not free to leave. No magic words are required to effect an arrest. They don't even have to say it. They don't even have to tell your ass you're under arrest. They don't have to say anything because it's based on their conduct. It's based on what they are doing. A search incident to a lawful arrest is permissible even if the arrest takes place after the search, as long as the arrest is supported by probable cause, and formal custodial arrest takes place quickly after the search. Let's see. A seizure occurs when an officer in some way restrains the liberty of a citizen, or is not your freedom restricted when you are stopped in a traffic stop? Is it not? Are you free to leave before the officer issues you that traffic stop in a traffic stop? Hell no, you ain't. They're gonna try, man. They're gonna try to come up with some type of attempt to elude. Ain't no telling what they'll come up with. That's because your ass is arrested. You are not free to leave. A seizure occurs when an officer in some way restrains the liberty of a citizen through means of physical force or show of authority. In other words, a person has been seized if a reasonable person would have believed that he was not free to leave. That's why I said that in my complaint, y'all, when I sued the police. When they surrounded me in my car, one of them had their hand on their gun and my back was against the car. And then they demanded one of them demanded in a more aggressive tone for me to show my ID. Based on all of those facts that I witnessed, because I am a witness, I reasonably concluded that I was not free to leave. Do y'all see how simple that is? And I won my motherfucking case. There was something else I wanted to show y'all. I'm going to see if I can find it. Give me a second. I'm going to pause the video. All right. I think this one is also worth reading to y'all, so I'm going to read this too. Here's my opinion, my personal opinion. This is based on research that I have done. The terms traffic operator, motor vehicle, and driver are all commercial in nature. It is commerce. A traffic stop is an arrest, which is why there's a bond requirement. A promise to appear is taken in the form of an admiralty bond. I'm going to read y'all that shit in a minute once I finish reading some of this stuff. I want y'all to see this shit, man. An appearance bond is generally defined as a type of bail bond required to ensure the presence of the defendant in a criminal case. Under Wyoming law, a promise to appear serves the office of a bond in securing the defendant's appearance in court. There's the case. Not sure why they cite Nebraska, unless I might have did this wrong. I might have cited it wrong or backwards or something like that. But anyway, let's see. A traffic offender may be permitted to leave on signing a promise to appear. If the arrest is for speeding, it is generally mandatory that the arrested person be released on the signing of the promise to appear. In many respects, the promise to appear is the functional equivalent of a personal bond. And this is by, looks like the Texas Attorney General. Scroll down a little bit more. Further, in characterizing the legal effect of an appearance bond, it was described as a contract whereby a defendant promises to appear or promised to appear. There's the case. The term promise is defined in restatement contracts. Notice you see this? You see this? A promise is a manifestation of intention to act or refrain from acting in a specified way, so made as to justify a promisee in understanding that a commitment has been made. And here's their reference, what they're citing in support of why they're saying what they're saying. Here's the citations. Promise, as used in the restatement of this subject, denotes the act of the promiser. If by virtue of the operative facts there is a legal duty to perform, the promise is a contract. But the word promise is not limited to acts having legal effect. Like contract, however, the word promise is commonly and quite properly also used to refer to the complex of human relations which result from the promiser's words or acts of assurance, including the justified expectations of the promisee, including the justified expectations of the promisee, and any moral or legal duty which arises to make the good the assurance by performance. To make good, not the good, but to make good the assurance by performance. The performance may be specified either in terms describing the action of the promiser or in terms of the result which that action or inaction is to bring about. And then here's the case right here where you can go and read that. You know, because I obviously don't know what the fuck I'm talking about because I don't read, you know. At least that's what this troll thinks on my channel. Not gonna mention his name because he's irrelevant. Y'all also, y'all don't let that man bother y'all, man. Y'all gotta cut that out, man. Don't let that man get on y'all nerves, man. Because it doesn't bother me. Here's another one I want to read to y'all. They're doing business with you. That's what they're doing. I'm not going to read this again because I've already read this in the previous video. What I am going to read right here, when it says deemed, I'm going to tell y'all what they mean by deemed. When it says right here, when an e-ticket is issued by an arresting officer, a person shall be deemed to have given his or her written bond to appear deemed. Let's see what deemed means. Black's Law Dictionary, deem as to treat something as if, one, it were really something else, or it had qualities that it does not have. An example of this would be, although the document was not in fact signed until April 21st, it explicitly states that it must be deemed to have been signed on April 14th. Blah, blah, blah. Black's Law Dictionary goes on further to define deemed. Deem has been traditionally considered to be a useful word when it is necessary to establish a legal fiction, which is not real. Anything that is legal is not real. Those are all fictions. To establish a legal fiction, either positively by deeming something to be what it is not, or negatively by deeming something not to be what it is. All other uses of the word should be avoided. Here's the case right here that supports that citation that I didn't read because I obviously don't know what the fuck I'm talking about. Anyway, an appearance bond is a contract. The appearance bond contract clearly provided for forfeiture of the bail if the defendants failed to appear as scheduled. There's the case right there. An appearance bond is a contract of the defendant and the surety with the state. These folks are doing business with you. This is commerce. This is fucking business. See, they're confusing y'all because they're hiding by this name, State of Alabama, State of Georgia, State of New York, State of North Carolina, State of Wyoming, State of Nebraska. Those are all corporations. All of them are corporations. All of them are persons. All of them have EIN numbers and all of them have DUNS numbers. An appearance bond, such as the bond in the present case, is a contractual undertaking within a criminal proceeding. And there's the case. There's the case. So there's something else I want to show you. I'm going to see if I can find it. Let me pause the video again. Okay, y'all, back. This is my ebook that I was working on that I obviously cannot finish because I don't have the time. It's called It's All Admiralty. So I got this information by doing research from Clerk's Praxis. Clerk's Praxis is a lead commentary on the jurisdiction of admiralty. I've actually seen that in cases. But anyway, so I'm gonna read y'all this because I want y'all to see that this is business what they're doing with y'all, man. All of this is admiralty jurisdiction. All of it is. In admiralty courts, the first process is frequently to arrest the defendant, traffic stop, and then take the recognizance or stipulation of certain fight, whatever. This is some type of Latin word, but there's a footnote right there. You see that one? That's a footnote right there. So I'm gonna go down and read that footnote to y'all in a minute, in a second. Or stipulations of certain blah 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 in the nature of bail, civil law, a surety, a guarantee, a person who undertakes to answer for the debt or obligation of another. You see that? It's not yours. It's not your debt. This even proves that the so-called name that they're attaching these so-called criminal charges to is not you. These stipulations within the bonds are of three sorts, namely, and they're all in Latin. So I'm going to skip the Latin names and read y'all everything in English. But y'all can see this for yourself. I would advise y'all to go and do your research on this. Whatever this is, by which the party is absolutely bound to pay such sum as may be adjudged by the court. 2, blah, 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 by which he is bound to appear from time to time during the pendency of the suit and to abide the sentence. 3, or the ratio or the rado, which he engages to ratify the acts of his proctor. Proctor in admiralty, they're not called attorneys; they're called proctors. If I'm not mistaken, that's what they're called, proctors. In admiralty courts, bonds are called securities or cautions and are agreed upon between the parties in one of the 4 following types of bonds. Pay attention, y'all. Pay attention. 1, by sureties. There's a footnote right there. 2, deposit. There's a footnote right there. I'm going to read y'all these footnotes. Now, the bonds in admiralty, they're in Latin. So I can't really pronounce these Latin terms. So I'm going to read y'all the words in English. So the first one is by sureties, 3. The second one is by deposit, 4. The third one is by oath. The fourth one is by a bare promise. Yeah. Let me see. Is that it? Yeah, that's it right there. And the fourth one is by a bare promise. So there's 4 of them. 1, 2, 3. Yeah, that's right. That's right. So y'all can see these bonds right here. Okay. So let's go up here, and I'm going to explain to y'all what these, for example, what a surety bond is, what they mean by deposit, what they mean by oath, what they mean by bare promise. Because I'm going to explain that to you in the footnotes, because I have footnotes in here from other from court cases and from just from doing a lot of research on what this stuff actually means. So let's go to the first one. Let's see. By sureties. So that'd be a footnote 3. So let's go to number 3. This is called a surety bond, where a bailman company issues a bond, i.e. promise, to the court on behalf of the defendant and becomes a surety guarantor on the bail. That's one of them. Okay. That is an admiralty bond, just to let y'all know. I have used one of those bonds before to get out of jail. That's a fucking admiralty bond. Let's go on to a deposit. What they mean by deposit. 4. So let's go down to footnote 4. This is called a property bond, where real property is pledged as surety for the bail. A pledge is a transfer bailment, or deposit of personal property as security for a debt. 72 Corpus Juris Secundum Pledges, Section 3, 1987. That is an admiralty bond, just to let y'all know. Y'all hear when y'all hear these rappers saying, mama got to pledge, or I gotta pledge this house as collateral to bond out of jail on this charge, some shit like that. That's admiralty. That's an admiralty bond, just to let y'all know. Let's see. By oath, there's a footnote, number 5. So let's go to the 5th footnote. This is called a personal recognizance bond, aka signature bond. This security, i.e. bond, is given where a party is too poor to find sureties at the discretion of the court. I have used one of those bonds to get out of jail before, just to let y'all know. And I'm quite sure I'm not the only one who has used any of these bonds to get out of jail. It is all admiralty. Let's see what this one is. By a bare promise. Footnote 6. This security is unknown in the admiralty courts of the United States. So they may do it in the states. Notice I said United States and not the state. Those are two different places, ladies and gentlemen. Just to let y'all know, they are not the same. The United States is located exclusively in the District of Columbia. The United States is a corporation that represents the United States of America. That's what it is. So now just to, show y'all that I know what the fuck I'm talking about, because obviously I do, because I do my research. Anyway, in Alabama, okay, pay attention, y'all. Pay attention. I just read y'all all of these bonds, and I just told y'all the elements of these bonds, okay? In Alabama, there are 4 types of bail provided for in Section 15, 13, 111, Alabama Code 1975. A cash bail, judicial public bail, professional surety bail, and property bail. Cash bail is where cash in an amount equal to or part of the total sum of the bail is paid out. That's one of the bails. That's one of the bails that they use in Pennsylvania. So in about 10 days, you got to go down there and post some sort of cash bail or some other type of bail within 10 days. Judicial public bail is where a defendant is released without any security and is granted only when the defendant meets the requirements of Section 15, 13, 145. So that must be a recognizance bond, if I'm not mistaken. Yeah, I think that's a recognizance bond right there. Professional surety bail is where a qualified company, scroll down, issues a bond to the court on behalf of the defendant and becomes a surety on the bail. Property bail is where real property is pledged as a surety for the bail. Let me see something. And there's the case right there that explains to you all of these bonds. All of those bonds that are mentioned in that case, in that statute that they're citing in that case, are admiralty bonds. Every single one of them are admiralty bonds. That's because they file lawsuits against y'all. They are litigating in the jurisdiction of fiction. They're filing lawsuits against you in the jurisdiction of fiction. That's what I call it. The jurisdiction of fiction. Let's go back. Where was I? I think I'm gonna end the video right there. I did want y'all to see that. I really did. Anyway, that will be the end of this video. I hope y'all learned something. I really do. If you haven't, please hit that like button and hit that subscription button. The Supreme Litigant is out. Peace.